Hello everyone, welcome to Legal Darshan. In today's video, we are going to discuss case number 2 given in the list of AOR leading cases released by the Supreme Court. This case is Maneka Gandhi versus Union of India. It is a 1978 judgment, and this judgment is a landmark one. I believe that all of us, when so there are some cases when we start our education, when we start our legal journey, there are some cases like Maneka, there are some cases like Vishakha, Keshwanand Bharati, of course, Minerva Mills. We get to know them in like a moment, in like the very first year of our law schools, that these are some keynote judgments of the Indian Supreme Court that have really shaped and helped in contributing to the jurisprudence, Indian jurisprudence of liberty, freedom, fair trial, etc. So Maneka is also one such case, which is talking of number one, the Golden Triangle, 1921. I believe that all of us, we know that the Golden Triangle was first talked about in Maneka Gandhi versus Union of India. It encompasses Article 14, 19, and 21, saying that these three articles are corollary to each other. One cannot sustain without another, which is in today's situation, which is a very appropriate relationship being drawn in Maneka. Now, to come at Maneka, we need to look at three aspects. One is the interpretation of Article 21 that Justice Krishna Iyer and Justice P.N. Bhagwati are adopting, relying on the United States and United Kingdom's precedents, right? And then we need to look at two cases. One is AK Gopalan, and another is another landmark case, which is ADM Jabalpur versus Shivkant Shukla. Okay, this case is a very famous case, Shivkant Shukla's case. This case is very famous. I want you to comment down in the comment box below that by what name is this case famous. This is a 1976 judgment. It is related to Article 32, also emergency and detention, etc. Okay, so I guess I am dropping some major hints here, and some of you are able to, recall this judgment, ADM Jabalpur versus Shivkant Shukla. By what name it is also known as, you need to put down in the comment box below. Okay, so now when we go back to Maneka's discussion is very, very relevant for the purpose of Article 21. Now, why Article 21 it is relevant? Because here the Article 21 reads, no person shall be deprived of his life or personal liberty. The word used here is person shall be deprived of life or personal liberty except according to procedure established by law. Now, what does this term procedure established by law means? Maneka is redefining that. So this judgment, this whole judgment running into 156 pages in the case of Maneka, is also throwing some insight. It is also enlightening how judiciary rewrite into legal provisions, giving them a whole new interpretation, which might or might not have been the intent of the lawmakers. Okay, so to come to Maneka, I believe it is very, very, very essential that one needs to look at what happened in AK Gopalan. Okay, so AK Gopalan is a Preventive Detention Act based case, and the AK Gopalan, in this AK Gopalan case, the petitioner was a Communist Party member or person belonging to Communist Party. He was detained under the Preventive Detention Act. Now the case is being contested on the grounds that you can put a person behind the bars, but you cannot snatch or strip him of his personal liberty. You need to give him rights of fair trial, rights of fair hearing. He should be known why he is put into detention. Okay, so in AK Gopalan, what is happening? A very a four-cornered, four-walled verdict has been adopted. So in AK Gopalan, that phrase procedure established by law is being read as the black and white law. Okay, so the judges in this case are saying that herein Article 21, it is mentioned that no person shall be deprived of his life or personal liberty except according to procedure established by law. And the language of this article therefore means that procedure established by law is the law that is written by legislature. Okay, so that is the procedure established by law. So if an article, if a section, if a provision of any legal statute of any legislature is saying that you can detain a person without giving him adequate reason, that is a valid procedure established by law, and you can deprive a person of his life and liberty because the procedure allows so, because the intent of legislature allows so. Okay, so when we read Article 21, no person shall be deprived of his life or personal liberty except according to procedure established by law. The sequitur here is that a person may be deprived of his life or personal liberty if it is allowed by the procedure established by law. So this was the sequitur was the finding in the case of AK Gopalan, where the court is saying, where the court is confining the meaning of procedure established by law to what is written in statute. If the statute permits, so it is the intention of legislature, it is the lawmaking that should be carried forward. Now, in AK Gopalan, there is one justice who is also sitting in Maneka, I believe. Yeah, let me come back to Maneka. Yes, so Maneka, in Maneka, Justice Fazal Ali. Yes, Justice Fazal Ali is there. He is also there in AK Gopalan, and Justice Fazal Ali is basically looking at yeah, Justice Fazal Ali is looking at Article 32. He is looking at Article 21 in AK Gopalan as well. And he is giving a minority verdict that this procedure established by law in Article 21, this term procedure established by law in Article 21 needs to be looked as a procedure which is just, equitable, and fair. But again, because it was a minority verdict, it was not given enough value, not even enough footage, because majority verdict decided that law should be uh, law procedure established by law should be the only procedure which is confined in the black lettered law at that time. Okay, so AK Gopalan was a very narrow construction of liberty, in my opinion. But however, this view was later overruled in Maneka Gandhi's case. Okay, so now Maneka is highlighting what Justice Fazal Ali has said in AK Gopalan's case. And now, in Maneka, what is happening? We are rewriting into Article 21. We are rewriting into procedure established by law by giving it a meaning that it is not merely the procedure established by law, but rather it is the due process. Due process means that it should comply with principles of natural justice, giving right of fair hearing and opportunity of fair trial. So law must not be just the written one, just the procedure established by law, but it must be just, fair, and equitable. Okay, just, fair, and equitable. And how will you decide what is just, fair, and equitable? We will decide them in the light of principles of natural justice, right? So this is what Maneka is revolving around. Now, coming back to the intricacies, to the details of Maneka. So in Maneka, what is happening? Maneka Gandhi is she's a very renowned person relating to Indian politics. Now, Maneka Gandhi's passport is being impounded by the authorities in the name of public interest, because there is provision, section 10 in the Passports Act, which allows so that a passport can be impounded, that a person, authority has the power to arbitrarily impound the passport in the public interest. Okay, now this provision is being challenged in the court of law, where Maneka Gandhi's passport is impounded and she is not able to travel abroad. And now what is happening in this case, what is happening in Maneka is that it was said that, article as against AK Gopalan, Article 21 should not be construed narrowly. Okay, a wider interpretation of Article 21 is taken in account in the case of Maneka. Okay, so Maneka basically says that section 10 clause 3, which is, giving the authority to impound the passport is not per se violative of Constitution of India, but when it is exercised in violation of principles of natural justice, it becomes a violative of Article 21. Okay, so here what is happening? We are now, the most interesting thing, that the thing that I find most interesting about this judgment is we are identifying the right to travel abroad. We are identifying that there is a right to travel abroad, but we are identifying it under Article 21, because in Article 19 we have the right of movement in the territory of India. Okay, so we do have a right to movement, but the right to movement is in Article 19 is limited to the right to movement in India, whereas when I am coming to Article 21, this case is recognizing that I do have a fundamental right to travel abroad. Okay, so the right to travel abroad is being recognized in Article 21 in this case. This is one thing you should also be, noting out. Now, when I talk of this judgment is expanding. Now, the main crux is passport gets impounded, and the Supreme Court is criticizing the decision because Maneka was not given the reason why the passport were impounded. She wasn't given any fair trial, wasn't given any opportunity to be heard, and her passport was basically impounded, so she could not travel. Okay, now here the court is saying that it's okay, you impound the passport, but the procedure established by law written in Article 21 means due process, which means that you can take necessary action, but you cannot take them without applying principle of natural justice, without giving the other person opportunity to be heard, opportunity to put his point, right? And if you are not doing so, that exercise of Section 10 in Passports Authority Act, it is violative of Article 21. Okay, so here Supreme Court, now why judicial rewriting? Because judiciary is reading due process in procedure established by law on its own. Okay, so here we do notice that there is judicial activism. Judiciary is taking account of what is the need of the hour, and it is transporting that meaning into the Indian law. Now here Justice Krishna Iyer and Justice Bhagwati, they are both looking at the foreign precedents. Okay, so this judgment is also significant because it shows how foreign laws are actually they are bringing value, they are adding value to the Indian interpretation as well. So there is one piece by Professor Upendra Bakshi. If you ever come across Professor I.P. Messi's book on administrative law, Professor Upendra Bakshi has written a preface to it where he is basically looking at Maneka in one of his extracts, in one of his portions he is discussing. And he's saying that, even in Maneka, there is a foreign influence, there is an influence of developed nations law, UK's law, West influences there, UK's influences there, US influences there, and it is adding to that influence, it is giving into that influence, that Indian law is being developed in the light of how UK and US are developing their laws. So due process, we are, bringing in Indian jurisprudence from the United States, where Justice Bhagwati and Justice Krishna Iyer are noticing that. Okay, so now here principle of natural justice became a part of fundamental rights, and it was held that we have all, come across E.P. Royappa's judgment. So E.P. Royappa's judgment says that arbitrariness is and equality is antithetic to arbitrariness, right? So to end arbitrariness, we need to have equality. Now this judgment, because here the passport was being impounded arbitrarily, this is also a violative of Article 14. That how can you how can you take my passport and not the passport of somebody else just in the name of public interest or general interest? Okay, you cannot do so. So here I am being, my passport is being arbitrarily detained. So when I am being a subject of arbitrariness, my right to equality also gets denied. And from here comes our golden triangle, Article 9, Article 14, 19, and 21, which was said to be a set of rights mutually dependent on each other, mutually inclusive of each other, and violation of one attracts the violation of another, right? So this whole judgment changed the principle of natural justice jurisprudence in India, laying more emphasis on principles of natural justice, laying more emphasis on due process, on reasoned order, right to be heard, right of fair trial, rule against bias, right? So this case is a very landmark case in upliftment of principles of natural justice in India, overruling what has been said earlier in AK Gopalan as well as in ADM Jabalpur case. So this case is relying more on the in minority view in AK Gopalan's case, which was delivered by Justice Fazal Ali, and in ADM Jabalpur as well, which was given by Justice H.R. Khanna. Justice H.R. Khanna, who also is known famously for Keshwanand Bharati's verdict because he was the seventh judge to sign the majority verdict in Keshwanand Bharati. Because Keshwanand Bharati was a close fight of 7 is to 6 majority for 13 judges bench for a bench of 13 judges, and Justice H.R. Khanna also in ADM Jabalpur is advocating for fair trial, fair process, due process, whereas the majority verdict is not aligning with that. Okay, so this was taken this became a cornerstone. Basically it became a cornerstone judgment in the light of civil liberties in India, and it you know marked as a starting point of civil liberties jurisprudence in India as well. Now, when I come to another aspect of this is that this case is also talking of post-decisional hearing. Now, what happens? This is very interesting. What happens is that there is a right to be heard. We all know audio alterum partem, right? Now, in audio alterum partem, it is said that I do have a right to be heard. No, but this case is saying that because you impounded Maneka's passport, you could not give her a pre-decisional hearing. A mandate tha, legal mandate tha, there was a legal provision, you could not give her a pre-decisional hearing. And this case led down that in case you are not able to give pre-decisional hearing to the person, you are mandated to give a post-decisional hearing. Of course, post-decisional hearing does not suffice for the pre-decisional hearing, but it should be carried out so that audio alterum partem, the right to be heard, is somehow preserved for the person contesting the case. Okay, so this was the finding in Maneka's case. I like this case so much. This case I personally like so much because it is talking about judicial rewriting, how judiciary sometimes rewrite into the provisions, exhibiting judicial activism, of course, and how they glorify the law already written, and extends its scope to development of civil liberties, and majorly of the people who might be arbitrarily detained or arbitrarily subject to arbitrariness, right? So this is one landmark judgment we have discussed today. We will be coming up with the remaining ones soon in time. Thank you, everyone. Have a nice day.